PI is not even hired until after the PR is upon it. So, you know, a lot, I mean, it can be a long time because, you know, the PI has, I mean, for many, many reasons.
How about if we were to do this? That we require the 30-day notice. You know, I'm a little troubled adding, duplicating the notice requirements. Rather, if we're to do this, rather than this special notice of the probate to DA, no, because it might be a regular probate. So we do want to, I mean, because there might be other assets.
Well, and there's still an estate recovery issue.
Yeah, right. So we would leave that in, but then we also say that, you know,
Well, everything after section 5 should only be estates with wrongful
Right.
Everything else.
But I'm trying to say that in this notice provision, we leave the 30 days in for notice to DHS and the health authority. And then we say that upon the giving of notice pursuant to of the claim pursuant to chapter 416.510, that we require a proof of mailing of that notice in the probate. So we don't create a new notice requirement, but they just have to say that when they've given that notice under 416, that they have to file a statement to the effect that they have in the probate that they've given that notice.
So there are two different notice requirements, 10 days after initiating the claim,
Yeah.
and then 10 days upon reaching settlement. We're just talking about initiating a claim or applying for assistance, or which one?
I got lost somewhere here. I'm sorry.
So there are two different.
In chapter
requirements.
416.
Where are we?
So what's that?
Where are we right now?
What Lane said was add a requirement to give notice of the claim for the proof of mailing of the notice of the claim in probate of the claim in 565.
Right.
That was Lane's
Right.
proposal.
Okay.
Rather than creating that early notice to the CCO, because that may be premature, we just add a proof of the giving of that notice in the probate proceeding
Okay.
when it's required under chapter 416.
Okay.
And where are you gonna put that?
That would be new sub 6. That upon the giving of notice required under 416.510, that they have to file a proof of that notice in the probate proceeding. So we're not creating a new notice requirement, just that we're signaling everybody that you've got one more notice that's required.
So we're taking out the 30 days.
No, I think we probably leave the 30 day because that's an estate recovery issue, and there may be other probate assets that pop up or what.
But we do need a time frame for filing this proof of mailing.
Well,
So with this 30 days.
yeah, or within 10 days, because that's a shorter time frame on that notice too.
So what happens a lot of times is the PRs are appointed so they can begin discovery. You
Right.
don't know if there's a claim there.
Right.
Then under the 530 notice, it says that you have 10 days
Yeah.
from making a claim or being action to enforce the
Right.
claim.
And that's when you would file proof of the giving of the notice in the probate.
Oh, that's
So that they may not have a claim, they may have not done action, they may be, oh, we need a PR because we need to discover to see if
Right.
there is a claim.
Right.
It may not happen within 30 days from appointment.
And you're saying just make a brand new subsection 6
Yeah.
where you don't say within 30 days. You
That's
just say
right.
Oh, so you don't offer.
No,
you're saying that you
we're
do
not
want
requiring
30
those to the CCO within 30 days. We are requiring it to a state administration and OHA,
Okay.
benefit recovery and all of that stuff. But if you get to the point of making a claim or initiating an action, all we're doing in here is signaling that you have to file proof of notice, proof of the giving of notice that you've given it as required in chapter 416
Okay.
at that point. So it's not a new notice requirement, just a proof that you've given notice.
So Shannon, what notices should that proof be required from it? You said, I think, 416.5.
Yeah, 416, 530 is the notice we're talking about right now, but if you go one layer deeper into the OARs, there are actually two different times that you're required to give notice as a tort attorney. You have to do it when you're initiating a claim or applying for assistance.
And then you also have to do it within 10 days of settlement or compromise being reached. And so,
Well, actually, technically, the 10-day notice after the settlement isn't for the plaintiff. That's the responsibility of the defendant,
okay.
Okay, good.
which they never do.
Okay, we're not gonna worry about that.
Yeah.
That's PR's responsibility.
The probate attorney would be filing this in the probate, but the PI attorney is the one who's responsible for doing this.
No, I think the personal representative is responsible for doing all of this.
Well, under chapter 416. Oh, well, yeah, is that the PR? Well, yeah,
But see,
because
then
you're,
it's again, the probate lawyer saying to the PI.
right, you gotta do this.
You gotta do
Yeah,
this.
right.
Yeah.
Yeah, I think it's okay. There's coordination.
I mean, I'm sorry, this idea that somehow the PI attorney and the PR attorney are totally separate entities
Right. No, no, no.
operating
Yeah, no, no, no.
independently. is
You're okay.
just-
You're okay. I think we will, I think it's appropriate for PR file.
I'm fine with that. You know, we actually send out a letter saying these are your reporting requirements.
Right.
You need to make sure you're doing that. You know, we're doing this, but it doesn't, you know, the notice information, and we should talk about this maybe too, doesn't necessarily overlap with what's required in the probate court, with what's required by the PI attorneys under OAR 416. So they aren't identical. What information needs to be provided.
Right.
Yeah.
So we leave 5 as it is. That's your standard probate notice. We had a 6 that just says within 10 days after giving notice as required under 416.510, PR files the proof of the giving notice.
Yeah.
Oh,
5:30.
5:30? Okay.
And so all I'm saying is that we're making sure that all the information required under 416 is provided
Yeah.
by, which is great, I like that.
Because we're calling out the statute.
But we aren't necessarily making sure that first, the notice to DHS and the OHA that we have all the information required under the OHA.
No,
So we're making sure that they're getting all the information they need. It's a CCO, but we're not making sure they're getting all the information they need if it's to DHS or OHA.
within that 30-day period.
Isn't that
If they're required to give notice to the Department of Human Services under 416.510, then they have to give notice and file proof of notice that they've given that.
So, you know, under the 416 statutes, you have to give the names and addresses of all the parties, the copy of the demand, case numbers in county where the underlying wrong. So that those requirements don't necessarily overlap with what we have proposed here in subsection 5.
Oh, and not at all in 5. In 6, you're just going to say that you've complied with the requirements of 416, of the notice under 416.
And you guys are fine with that
So
we're.
it's a statement of compliance.
A proof of mailing.
Proof of
Yeah.
mailing.
Yeah.
That'd be great.
But they don't have to attach the copy of the email. Because some courts, when they give a proof of mailing, they want an attachment of whatever was mailed. And actually, I think the OLC 9 is a little unclear about that too.
You know, because the notice that you would send could be, how big is the notice? What all is
It
involved?
sounds like there's a lot
Quite
of.
a bit.
Yeah, it's more than what's required in our section 5 here.
Compliance signed by the PI attorney might be a good thing.
And affidavit of.
Yeah, I was working with the PI attorney too, so.
Yeah, I think maybe in that case, not filing not filing a copy of the notice, but a statement, again, a statement of compliance or a sworn statement, declaration, affidavit, whatever we use.
I'm just wondering if we should just say there's a statement of compliance that when we filed, the notice has been given to DHS, OHA,
yeah.
and the CCO. Yeah.
Whatever's required, I would just say whatever, in compliance with
Okay.
416,
Yeah.
so that we're not restating
Oh,
anything.
okay, perfect.
Yeah, we're not gonna recreate that, we'll just say, we've done what 416 says we have to do.
Yeah, okay, like that.
Yeah, it sounds reasonable.
And
I'd
that
like to
signals,
figure out
that
what's wrong.
that tells the PR, the lawyer, that you gotta make sure you work with the PI lawyer to get this file. Okay,
And then wait, so the 30-day change to.
we leave that in.
With the coordinator.
No,
We don't care about that.
No, we don't do, well, we do, but we care about that.
We don't care.
It just needs to be filed before we close.
That's right. Well, it needs to be filed within 10 days after you've given the notice in 416.
But if you just reference for.
But that's right, all you're saying is in compliance, yeah,
To make them.
that's right. That's all it is, just to make sure
So
that they
this
do.
will be filed with closure documents. things as well.
Well,
Well, but if you're saying you complied with it, I'm saying that I gave it within 10 days. My compliance can be signed any time as long as I've done as I've complied with the statute. I do not file the compliance within 10 days. The filing with the court is separate from what I've done because I have given you notice within 10 days. This is simply a document saying, yes, I've complied with all of those things in 416.
So that goes in, that we don't need it in subsection 6, we put that in section 7 in the affidavit of compliance. Yeah, the only reason I was thinking of putting it sooner would just be to make sure that we don't get to the end and find out that there isn't compliance. Then what do you do?
well, then they have to do it.
Yeah.
You can't close the estate.
Yeah.
You have to give it.
And that's really kind of attracting and wary. So really, it is kind of better to have it be separate. Because if our audience is kind of bumping PI lawyers, it helps eliminate that attracting and wary, earlier they have.
But see, if you're requiring additional things for the court to track and require,
That's a good one. That's additional resources.
And there's an affidavit of compliance in the regular states that they have to search for
Yeah.
waivers, and the courts aren't tracking all those being filed, they're just making sure it's filed before they're allowed the cases to close.
Yeah, we won't have that one in this stupid, so.
All right,
I think it should still be subsection 6 under section 6.
you do.
Yeah.
We
because-
want a special proof of mailing more contemporaneous to the giving of that notice than waiting until the end of the probate.
No, not here. Okay, but not having a timing requirement, just as long as everyone's paid, we're all happy, right? And so as long as the notice is going out at some time, yeah, I mean, yeah, exactly. So when I read subsection 6 versus subsection 7 is titled waiver of requirements.
Yeah.
Sticking under that.
Yeah, we gotta retitle that statute,
Okay.
because we're gonna put some requirements in there, it sounds like.
Yeah,
Yeah.
I mean, so that's why I'm gonna put it in there, but under subsection 6, it just says information to beneficiaries of the Department of Human Services and OHA. So then it's like, okay, well, have you complied with that as part of that section, but not having the time period to do it is important because you never know. Sometimes you settle cases without filing claims. You know, sometimes you do it right at the end and then you're ready to talk to the state.
All right. So let's move to section 7 and see how this comes together. And then let's keep in mind, we may need to restructure this because it's not just a waiver now. Although we're saying is we are waiving the information to deceased heirs and interested persons in a wrongful death only, keeping in mind that if you find an asset, you're back into the regular probate. We don't require publication of proof of notice. We don't require proof of compliance and diligent search for claimants under the probate code. But we are going to require an affidavit of compliance with 30, what was the reference there?
So here's the problem that we created, if I understand
Okay.
things correctly. We're kind of doing away with section 5.
No,
No?
no.
Okay. I'm
Section 5
sorry.
stays.
5 stays as it's written now?
Yep.
Oh, wow, I got lost.
No, are you talking about subsection 5 of section 6, or are you
Oh,
talking
I'm
about
sorry, I was-
section 5?
Oh, right. I'm talking about
Sub-5.
section 5
Yeah.
of 6.
No, you're keeping that too.
Yeah, we're keeping that.
We are?
Yes.
Yeah.
that's why there's going to be substance.
So we're coming up with a new.
You guys are sneaky.
No, we're trying to come up with a new subsection to address your concerns, but it'll.
So there's still the notice to DHS
Yes.
under 6 sub 5.
Yes.
Oh, that's not what I thought. Oh, okay.
We're omitting 4,
We're omitting 4.
which is about the final count.
Well,
Oh, well, we're changing the language.
isn't subsection 4 about the beneficiary name?
Yeah, yeah.
I think we need to change the language to find.
Right.
Should say.
Yeah, that's right, statement of compliance, yeah. And then Marissa's already highlighted, let's go back and make a corresponding or conforming change there. So let's get to section 7, are we okay with 1A, B, and C? And then instead of, in 2, instead of saying this section does not limit or modify, is that where we will say that they have to file the affidavit of compliance, be more affirmative in the obligation there?
What's gonna be the title of that section?
Yeah, well,
So that would just be, you could have one section be waiver.
yeah, you could,
Another one.
you could, yeah,
It might be clear.
sure. John?
You said that all these requirements are waived, but if you find an actual probate.
Right, do we need to be more explicit about that? Yeah.
Where, yeah, what
Yeah,
makes
then we
sense?
have to put something in here that says if you find other assets, then you have to go to regular, and like, this doesn't apply or whatever, so I put it up.
Well, and so I think we also need to describe how do they initiate that, and my suggestion would be that they would have to amend the petition to initiate the probate. What document did they file to say, oops, we discovered other assets, we have to go to regular probate? So,
Well, an inventory.
yeah, but they need to shift over from that petition that says we're just wanting wrongful death to saying, okay, now we're regular probate.
Yeah, I like amending the petition.
Follow-up question, if we have no regular probate assets, why are we giving notice to DHS?
Because even though we can have we may have a claim as a provider of medical care in a wrongful death action. And we're starting to file those in addition to our liens.
So why?
And the other thing is, although I think we're addressing it, we've also traditionally submitted kind of what I call a contingent claim, saying we've got these other claims if there are any other probate assets.
So why are you the only favored creditors?
Well, it's interesting you raise that because I was going to suggest that there needs to be some sort of due diligence to find creditors who are covered under Chapter 30.
Yeah, so I'm thinking, why are we leaving all the other creditors out?
I wasn't going to recommend.
And then and I also, this is, I mean, I have the advantage of knowing nothing about this, so.
Well, that makes us equal.
No, you're just joking. And there's, I guess, the only logical reason I can think of about why you have to have a probate, even kind of a quasi probate procedure in tandem with the wrongful death only thing is, is if we find assets thing doesn't persuade me because, until you find them, you don't need to be in probate. So what seems to me to be the connection is that you've got this tension between a wrongful death action and they actually be a survival action.
Well, that's more or less one of the things I said last week was we're trying to wedge this wrongful death process into the probate code, and I'm not sure that we really should be doing that.
Yeah, but if you take it out of the probate code, then you don't have any way of testing.
Well, you're gonna have to build a whole new process to deal
yeah.
with the wrongful death.
And how do you differentiate between a survival action and a wrongful death?
Well, and that's a problem now.
Yeah.
We have people filing saying this is a wrongful death action. No, it's not. It's a survival action. And then when it comes time to distribute assets, they say, oh no, this is a survival action because I want to distribute it according to the terms of the will and not according to the terms of Chapter 30.
Or vice versa, because that's most people. So every creditor has a stake in that issue.
Well, and
Not just you, every
Right.
creditor. The credit card company has a stake in it.
That's been one of my biggest concerns about this whole thing is how do we distinguish a wrong from a, because oftentimes the people that are making that assertion really don't know.
But earlier, didn't.
Lane, this is Brooks. I'd love to chime in when it's appropriate.
Go ahead, Bruce.
Thank you.
Yeah,
Rick, I hear your concern, and I have that conversation with the plaintiff side PI bar pretty regularly. I will tell you, my experience differs from yours. I've never had one of them want to pretend that a case is a survival when it should be wrongful death or otherwise, just to affect who gets what pile of money. And from my point of view, that, as we all know, that's all driven by medical causation. If the tort caused the death, it's a wrongful death. If it didn't, survival. We know that. But I agree with you. Every creditor has the same interest as your organization in having it be characterized as survival if it is, if that money's all available. But I don't see the concern that you've got. And maybe, again, you see a swath of people that I don't bump into. But that is not a thing that pops up in my very, very frequent communications with these folks. Just hopefully that's a useful pile of data.
And earlier, didn't we discuss this? in
Yes, we did.
order That they identify?
yes,
Is it wrongful death?
Yes.
Or is it a survivor?
Right,
action?
right.
So, and if you're a survivor action.
you're in probate, right?
If you're not, then the creditors are, there ain't nothing to claim.
That's true.
And also,
No, except for the medical.
Well, right, under the wrongful death statute, yeah. Jen?
and Chris and I were talking to we're gonna put in the headers again, because
Yeah.
really the initial.
Oh,
You know, the first section is for personal injury and for wrongful death,
Right.
but anything after section 5
is wrongful death
is
only.
only wrongful death. Maybe we can even put in section clarifying that this only applies, just to reiterate, it only applies for wrongful death. Any probate assets, including the personal injury claim, are discovered a full probate. It needs to be initiated.
Of course, the headers have no legal.
That's right.
But at least it'll be clearer that the only, after section 5, that only applies when there's only a wrongful.
Where's that, is that in chapter 174, is that the statutory construction statute? Yeah.
I don't know,
Headers are not part of the statute.
the reason well, we usually put a thing saying the captain's term.
Right, okay, so, yeah, so
I mean-
what we need, is we are gonna require that the petition identify if it is a wrongful death action, and, you know.
I'm not saying to revisit that.
Okay, so,
And in the settlement.
and in settlement, that's right. And so I think we do need a section here that says explicitly that if assets that are subject to administration under the probate statute, under the probate, as assets of the estate are discovered, then they have to amend the petition, because we have different requirements, to comply with what 113 requires for a full probate petition. And the PR has to administer the statute in compliance with all everything in the probate code.
I mean, I was only,
Believe it or not, there is a possibility where you can have both.
What?
You can have both the survival and the wrongful death.
Oh, yeah. In which case, you do it all in a probate, a full probate.
Lane,
Yeah, Brooks.
that comment sort of triggers me. That's a trigger warning thing for me. I agree it's possible that on day 1 the person gets hit and their leg gets broken, and then on day 10 somebody else kills them.
Right.
But there can never be a wrongful death and survival claim arising out of the same tortious event.
Yes, it can be, Chris.
I've had attorneys make that argument.
Bonnie
If the
Richardson.
tort killed them, if the tort, no, there cannot. If the tort killed them, it's a wrongful death. If the tort didn't, it's a survival. If it's one tortious injury, it's one or the other, never both.
Wait, do we need to make that call in this case? No, we're just gonna put it to the lawyer to make that call? I mean, all you gotta do is say what it is. Huh?
Sometimes, for example, I'll just give you an example.
Yeah.
Okay, so I have one right now where the bicyclist was hit by a driver and he died. But he didn't die until years later. So at first it's, personal injury claim. Then the insurance company doesn't pay. And so now you're going to go sue the insurance company for not paying for the accident. So you have a claim for negligence for the survival action. But then, this is really tragic, because the insurance company didn't pay, the man committed suicide. So now we're going to bring a wrongful death action against the insurance company for failing to cover.
Oh.
So there are situations.
But that's 2 separate torts.
Well, there are alternative claims for relief, but it all arises out of, you know, the accident and failing to cover the accident for breach of contract and also for wrongful death.
But all I'm saying is, I don't think we need to decide that.
But that's too,
That's gonna be up to the lawyer filing the probate in consultation with the lawyer, the PI or wrongful death lawyer, to figure out what it is. And call it what they think it is, and
And it can change.
and it could change, and if it changes to the extent that it involves a probate asset, the survival claim, then they have to amend the petition and go through the probate process, because the survival claim is just a garden variety probate asset. John?
But that's my point. Every probate creditor has a stake in that determination. Whether Bonnie's right or Brooks is right or how it splits affects every single creditor of the decedent. And if the decision as to which way to settle this case is made solely by the litigants, are we giving the creditors due process?
So you're talking about going back to section 6 and expanding the, well, I guess in section 7, reinstating the publication requirement in a wrongful death only case?
I'm unable to offer answers.
Oh, only post problems.
I'm just all I can do is this, this kind of like a fundamental logic. It just seems to me like just get on big. And you can't, if you've got this tension, which you guys have all convinced me is real, where a claim could be characterized as one or the other. And if it's characterized as one, different people benefit, then it's characterized as the other. So everybody who loses by that characterization ought to have an opportunity to participate.
I don't think the characterization is random. I think there has to be a good faith factual basis to say this is a wrongful death. I mean, if it's a survivor action and you say, oh, let's just dress it up and put the lipstick on the pig, I think that's bad faith. I think that opens you to all kinds of other issues. You gotta have some facts to make a decision.
And I think it also opens us up to serious inactability issues with OTLA. If we now give the telephone company and every credit card company the ability to come in and argue with the PI lawyer that you've characterized this as the wrong kind of claim. I think it's,
comment me if I can, Lane.
yeah,
That's why the judge is the one who's finally decides.
Brooks.
So you've already got detailed requirements for the affidavit when the lawyer wants to settle, and nobody cares how we characterize the claim until we get to the point of settling the wrongful death claim. You're going to require as only claim, which I don't think is currently needed, and I think that's a good improvement. If what we're trying to do is legislate around the fact that a particular attorney is going to breach their RPC duties and lie to the court, I am fundamentally against that, and that's our motivation. At this point, the lawyer has a duty to characterize it, and I'm going to fundamentally disagree with whoever says they had both. Those are two different torts.
That was your partner.
Number one, you didn't cover causing the suicide. Number two, guy broke my leg. I agree that we can have alternate claims that sometimes medical causation isn't clear, and we can end up in a gray area if we settle because the defendant says, look, I'll pay money, I don't care whether you think I killed him. But that all needs to be spelled out in this affidavit, which I think is going to be. And that puts the bench, who is the probate guardian, on notice to say, wow, I'm not sure what kind of claim that is, or I need more data, or let's go ahead and give notice to the phone company.
Right.
The bench is the backstop there. But if we're trying to legislate around the chance that someone will be unethical, I'm just going to say fundamentally that shouldn't happen. Done.
I agree with you. You want to have this conversation with John when he gets back to the office today.
I'm sorry, I have to respond to that. First of all, most of the people that mischaracterize the action is not necessarily because of an unethical conduct. It's because they don't know the difference. And second of all, I do get attorneys that basically say, oh, it's a wrongful death action or it's a survival action, and then at the back end, they do like Bonnie almost suggests, they try to say, oh, well, these medical expenses, weren't wrongful death, or these medical expenses were, and they try to bifurcate what they do. And that's part of their negotiating tactic when they're dealing with us.
But I'm just saying, if we require in the statute notice to every creditor so that every creditor has the opportunity to take issue with the PI lawyer as to the nature of the claim, we might as well stop this. It's not gonna happen.
Well, and I recognize that, and I gave up on this issue, but, I think John's point is very well taken. Why is
Well, the backstop there, and I want to just echo what Brooks said, I think, is that you're going to have to file the affidavit in support of your motion for settlement. And you've got the allocation that you've got to go through. Those are the opportunities for the court to look at this and say, I don't think this is a wrongful death action. Or I think this is something, there's a survival action in here. And I'm,
and I don't have an opportunity to be heard as a creditor.
Well,
I don't even get
you're
this-
already getting your 30 days.
Yeah, I know, but I'm talking as a generic creditor, which is what John was.
Yeah.
And then furthermore, I would go on and say that you got to remember, the creditor doesn't even get to look at the affidavit. It's now confidential.
Well, but it's fine. I'm just saying, if we want to add the creditors, then let's move on to the intermediate process, because this is dead in the water.
I agree.
So we're not going to do it.
We're moving on.
We're going to, it's not required today. We're not going to make it required. All right, done. What else in section 7? So we want to add a section that explicitly says that if the PR or if the court determines, if the court may decide in reviewing the affidavit that this isn't a wrongful death action, it's something else. That there are assets. I don't know that, but that there are assets required for administration, and you've got to then petition to go back through the process, right, for the protection of everybody. Just like a garden variety probate. So this only works if there is only a wrongful death to begin with, and nothing else is discovered in the intervening time before settlement or distribution of the wrongful death.
Lane.
Yeah, Brooks.
No, actually not Brooks.
Oh, sorry, who was that?
Matt Trump.
Oh, Matt, sorry.
No problem.
You look like Brooks.
On that point, I like the phrase that you just used, I think, if I heard correctly. I think you said if the court determines, and I think we should actually include something like that in the statute, because then it points further to the court.
Okay.
The court should also look at this and confirm that they feel it's wrongful death versus survival.
Okay.
And if there's any other assets. So I think that would be good.
You persuaded me that I was right. Oh, and Marissa already did it. So, okay, Matt.
Didn't we
Or Chris.
discuss earlier making some kind of requirement, not just that if probate assets were discovered in the theory that people are going to look for them, but some affirmative statement that probate assets were looked for?
Well, that's a conversation. What do we?
I think there should be some minimal duty, but I also think there should be an exception for unclaimed property.
Didn't we have something in here that, the PR has all the other responsibilities and all that, don't they already have the responsibility to marshal
Perfect.
the assets?
Perfect. Yeah.
So that if you're taking away from them the proof of compliance, the ability to search for claims,
That's clean.
not
That's,
for
right.
Marshall, yes.
Yeah. Let's just leave it at that.
So we're not gonna have a state that they've done.
No, because there are lots of other duties that they have as a PR.
You don't want to.
Yeah, because you're right. I don't want. Yeah, we're all of a sudden we're really complicating this to add some specific obligation there.
Well, so will there be a statement in the comments that they do have a duty?
Sure. I look to Susan. I want to make sure that in clarifying, in modernizing this, that we're not just, creating, a process that is just going to get bogged down, first of all, in front of the committee, and second, in real life. But, But I don't want to say you have to, every wrongful death PI lawyer or probate lawyer has to go onto the unclaimed statute website and look for a $20 check. Yeah.
So I like symmetry. And I think if we're not going to make any effort to police the distinction between a survival claim and a wrongful.
There is policing with the affidavit reasonableness and the review that the court gives of the settlement.
Okay, so if we're not really gonna police it, then I don't think we should make any effort to require people to actually do a real probate.
Yeah. Well, we're going to be.
People ought to be free to just ignore the probate, and when they find assets later and have problems later, start over again.
We're going to be silent as to that specific requirement. What?
You
Really?
don't get to start all over again and open another probate.
They can reopen the one they got later.
Yeah. Yeah.
Well,
But
but
that's
that's
part of
what
the
you're
process.
saying, you amend the,
Right. But John is saying, okay, you got a carefree PI and a carefree PR lawyer who's just doing this wrongful death, and they do overlook an asset that comes up after you've closed the wrongful death probate. And what we would say probably too, maybe just not only amend, but if they discover after the estate has been closed, they have to petition to reopen the estate and this as probate. Which they would anyway. That's right. Yeah.
but it's not necessarily the wrongful death attorney, it's the.
It's
person representing.
well, that's right.
And they're the ones that have the responsibility.
Yes, that's right. Yeah, this is a PR responsibility. Right.
So then, you still have a duty to file the inventory, which is a declaration under penalty of perjury.
Wait.
In this estate, because we have waived that requirement. So, and so the idea is the inventory will be zero. But, I mean, I would feel as a probate lawyer, the obligation to go search for unclaimed property.
Is tied to that.
Yeah, I mean, that's part of the duty of assets. And then you discover, there's a refund that's more than $100. And my feeling would be I would have a duty on behalf of my client to disclose that to the court. And so I sort of.
Good for you.
It's part of my process.
Yeah.
And
Even
so
though the $100 will be eaten up by your fee.
Well, exactly.
Yeah.
Exactly. But the problem is, in Oregon, that $100, it could be $10,000 or $100,000, and we have no way of finding that out. But so I sort of think we should have a de minimis.
No.
Well, then
No.
a way out of dealing with that issue, because that's gonna come up. I mean, you have,
Why do we care?
because.
What's it to us?
Because if you have a duty to report to the court any non-probate asset, you have to file an inventory with your client signing a penalty of perjury. Are you just saying the probate lawyer should not search for unclaimed property because we just said they have a duty to marshal assets?
But they'll weigh it wrong. If people want to proceed on the assumption that there are no other assets other than wrongful death and just deal with that and let everything lay, why do we care if they do that?
Because we just said they have a duty to marshal assets.
Well, it's our official duty.
Well,
We gotta
You have a person
petition.
representative who's a fiduciary.
right. But a fiduciary with judgment,
It's just a.
really, if you find a $100 check, yeah, who's going to reopen an estate to probate a $100 check? No, it ain't gonna happen. So there's a range of judgment, is what I'm saying, in the PR's general fiduciary responsibility. And I guess I could just leave it at that. Yeah.
They want more and fine when it becomes worth doing something now. They can reopen probate later. Why do we care that they do their job right? We're just kind of babysitting.
Because we have a duty to follow the statutes, and we're telling our client, well, here's the inventory that I did check for unclaimed property, so yeah, you're probably good. I mean, I don't know, I'm uncomfortable with that. Maybe I'm being too liberal.
Well, unless you're gonna state that as a requirement in every probate.
Yeah.
I
There's nothing special about this in that respect.
I think you're viewing it as a probate perfectionist. And if people want to be sloppy, it's their property, it's their problem. Why do we care?
Yeah. I'm inclined. So but we are still requiring inventory in a wrongful death only?
Right, because that
Well, why?
can tell the court's not to require that.
Well, that's right. We waive it, the courts,
Statute, we don't write.
you don't, yeah, I was gonna say, because you, I mean, I'm just thinking about that as you mentioned that, Jennifer, yeah, we don't have, we're proceeding on the assumption there is no estate asset, so why an inventory?
Because it's a sworn statement from the PR that you.
Well, your petition is
Is there
one.
an affidavit somewhere? Doesn't the affidavit say there are no assets?
Right.
So the inventory saying there are no assets is swearing essentially for a second time.
Yeah, you've already said that in the petition, that there are no assets.
The only difference is you're swearing after having had the powers of the PR to find assets.
But in the settlement, if it's solely wrongful death, you're swearing that
That it is
it's
solely-
solely.
That's right.
So maybe we need to add, then that one, this might eliminates my property
We just-
authority.
Waive the inventory.
Yeah, I think we waive the inventory.
So
So
then
how
that
does
was,
the PR paid for that diligent search?
Well, yeah, what
No, they don't
diligence
have
search?
to-
We're gonna waive the inventory.
Yeah.
So we add to section 7, the inventory required under
Yeah,
ORS.
yeah. Yeah, Okay. Well, I mean, actually, we're doing well. This is a robust discussion.
It's so good we're
What's that? You take one whenever you want one. It's through there.
Just through the street.
Through there and then out to the hall and to the left. The one we are too, yeah. Do you want to take us through the course for the conforming amendments?
These were just, they're not exactly conforming.
Oh, they're not, are they? Yeah.
Yeah. So, instead of the new venue,
Yep.
provisions that Shannon had, I just stuck them in.
Uh-huh.
Created the venue statute.
Okay. In 8, is it enough to say personal injury cause of action, or do we also want to say wrongful death?
It's like we would say on that.
Personal injury or wrongful death action? Judge, did you have?
I thought that we determined that was not going to be in the new statute. Brooks?
I don't think Brooks was here for that meeting.
So, yeah, I'm here.
Yep.
In the, were you here when we were discussing in addition to the county where they died or what a personal injury cause of action could be maintained?
Yeah, and
During that discussion,
you know, it makes a bit of sense to me if there's not gonna be any assets but this claim, to have the probate pending in the same county where the PI case is happening, so I'm not really bothered by that. That may be changing my position from before, but I've thought about it. The only thing I'd add on this section is, if we're dealing with a deceased person's claim when they didn't die, that's never a personal injury claim, that's a survival action. And maybe we could change those two words, personal injury to survival action.
No, we don't use survival action in the statute.
It's defined up here.
Yeah.
Okay.
And it's a cause of action arising out of injury to a decedent.
So personal injury would include.
Yeah, I saw that. That definition would rope in wrongful death, and that's inconsistent with 30075.
But does not abate upon the death of the decedent under 30.
Right.
Right.
I think that's right.
But a personal injury is a probate.
Yes.
I understand.
But
if it's so-
You're defining personal injury, I'm sorry, Judge, my apologies.
Yeah, good.
So saying that it's solely a wrongful death.
Right.
I understand. Personal injury action is a probate. That does not seem to be, because if I'm over in Baker County where I had a personal injury and all my assets are in Washington County, how are the creditors going to know what's going on there, right? It's because you've got your probate over in Baker County.
Well, I thought when we discussed that, it was that, there's a lot of counties you can file a probate in anyway.
That's
There's
right.
Property everywhere,
Uh-huh.
you're gonna basically forum shop, and creditors who are where you live might not know that you were gonna file the probate in this other place where you have property.
Yeah, if you've got personal property in a county, I mean, that gives you venue And a personal injury action is really just sort of a species of personal property. So, yeah, I think that's right.
So does that exclude probate court then?
No, I don't think so. I think we talked about this in before, that property, this is kind of the standard, any kind where property of the decedent was located at the time of death or is located at the time the proceeding is commenced, is our current venue statute. So that's not limited to real property, that's property.
So if I was injured in Nevada,
Well, then we're talking jurisdiction, not venue. Brian?
I was just saying, this is actually current practice in at least one large county.
We mean like Harney?
It's the size of Connecticut.
there's a lot of things about that.
Actually, that's a county, county, isn't it? I think it is. Okay, anything else in those, there's actually any more copy?
I have one other thing going back to section 7, it's a very important thing that is not waived, and that's the final count. I mean, that's what everyone wants to waive is the final count.
Oh, yes.
Oh.
We're gonna, yeah, and the certificate of compliance is going as an affirmative requirement.
And before we go on to that, I don't think you defined it. I think you defined it as itself.
What? Define what?
The survival action, it's, by saying it's a personal injury claim that is not a date, what you're really saying is it's a personal injury claim that is not a wrongful death claim. And a wrongful death claim is personal injuries that result from the death of the person. And so you're basically saying a survival action is a claim for personal injuries that is not a wrongful death action. And the wrongful death action, you got this cause and effect issue that distinguishes between the two and not addressing it. We're not identifying that as the difference between the two.
So that defines the definition of wrongful death action.
We said we were going to add that, and that is in the.
I think, because it is, I think the personal injury attorneys do get it wrong, so I want to understand the difference between the two, so we get it on definition.
That's what I think, if you're gonna.
So who's expert enough to give us that definition?
Rick.
Rick.
Yes, I can demonstrate.
Yeah,
And then we
yeah.
can put the movie right, the YouTube link in there.
Because the difference between the two is the cause and effect, right? So
Right, but
we have a
it-
definition that doesn't address cause and effect.
There are disagreements. So,
Uh-huh.
for example, somebody has a TBI, traumatic brain injury, and then they commit suicide. So was that because of the accident, right, that caused the TBI, which then they died, does that then turn it into wrongful death? I mean, so, but anyway, those are not as usual, but I think we'll find more of those coming out. But I think there has to be a definition of what is a survival action and what is a wrongful death.
So what about,
Lane,
Brooks.
Matt Phillips again, actually, I think we should look
Jeez.
at 30020, paragraph 1, which starts with, when the death of a person is caused by the wrongful act or omission of another, the PR may make this claim.
Right.
So that first phrase there is defining wrongful death action.
yeah, I was gonna say that.
And I was gonna say exactly the same thing, this is Brooks. And then somewhere in here, we also have a statute that says you can't have a survival action if it killed them. And I'll find that.
I found it now, it's 30075.
Yep.
So, yeah, so I was thinking we
Yep.
would put, that does not result in the death of the decedent or something like that, because that's what was got in 30075.
Okay, I like that
Yeah.
in concept to see in the next draft.
And that doesn't help with the problem that you identified where nobody really knows.
Then you just have a lawyer make the call,
Yeah, just tell them, at least part of this particular statute, this is what it means. This is when we use the statute.
Section 9, what have you done to us there?
So I'm not sure this is right anymore, because this is maybe an old decision. amount recovered.
Yeah.
Look at that, and then down here, it also includes amount recovered on a claim for wrongful death.
Yes,
It's not right.
that's correct. E comes out. Yeah.
I think that was a suggestion to pull that into the probate assets somehow, and then we decided that was a good idea.
Well, that was for purposes of the PR.
Yeah, and that's case law, so,
What's case law?
yeah.
What-
That the wrongful death, proceeds from a wrongful death claim are considered in the personal representative scheme.
All
Oh,
right, so that's why.
oh, that's
Yeah,
right.
Yeah, right.
That's right. That's right. That's right. This is the fee statute. Thank you.
Section 9 is the statute.
All right. So we will see another draft of this.
Yeah.
Good work.
So, I'm sorry to keep beating a dead horse. but
Oh,
we still have to-
how did the horse die?
Go
Yeah,
for
or
it.
is it just, yeah.
Well, we still have to address that's, we're gonna, that's in there, but the situation where the sole reason for bringing the estate is for the plaintiff, the injured plaintiff, to sue the insurance company and
Wait.
gets
The injured plaintiff?
in a personal injury. The
When a dead
plaintiff
person
is
is-
alive, the
Oh,
decedent
oh.
is dead, and they want to, we just want to probate to negotiate with the insurance company, the decedent, and that isn't, we haven't addressed that.
So Lane,
Yeah, Brooks.
I actually drafted some legislation that I've passed to a couple of interest groups to deal with the issue of a dead defendant with no estate. It's a giant malpractice trap for the plaintiff's bar. I would be more than happy to send that to whomever the right person is so this committee can look at it and see if they like it. Because right now, I spend a lot of time opening empty probates and getting lawyers appointed as PRs for the sole purpose of being served with a summons and then sitting around. And it's a giant waste of judicial resources that I'd like to solve.
Okay. What if assets of the deceased are found?
Then it's a probate.
Yeah.
So what I currently do with these is I open it and say, we know of no assets, please appoint me, waive bond, waive inventory, waive creditor claims because I have an empty estate. If I find any assets, I'll file a declaration and I'll do everything. But in the vast majority of these, I've had like 2 out of hundreds where we did find assets. Because normally, if the decedent dies and their assets needing probate, the family is motivated to do that. I get brought in where the process server tells the PI lawyer, yeah, the widow says he died a year ago. And then we have to run around and take, Judge Cobb's time or somebody to do this emergency probate to save the statute of limitations. And this may be beyond your purview, but the solution I came up with was, if at the time of filing there is no open probate for decedents, because maybe they already closed it, whatever, then service on any office where the insurance company does business is adequate to commence the claim, and it gets the plaintiff's lawyer out of the relation-backed malpractice trap, which is unique to Oregon. But I can do a memo and send that to you if your committee to look at it.
Sure, I think we'd like to see it. The other question I would have, in a case like that, could we amend the special administration statutes and handle it that
Well,
way?
you could, but you still have me, somebody paying a filing fee and me taking the probate bench's time to open an empty file that triggers all sorts of automatic calendaring stuff at their level.
Not a
Where it
special,
shouldn't be needed because there's
not a special administration, right? I mean, special administration, the judgment appointed
Well,
PR
yeah.
for special administration can say what the PR can do, and that really governs.
Well, sure, I agree, but I'm getting around the question of why do we need this figurehead called PR, whose only function is to have a process server hand them paper in their office or wherever, and then tender to the insurance company when it's the insurance company's actual rights affected because we don't have any of dead guy's money. Why are we even going through the fiction at all? But this is beyond your scope today. Let me send you all a memo and see if you like it, and if not, that's okay.
What do you call this person?
No, I'm skipping an administration at all. When the PI lawyer finds out that the defendant is dead and they check OECI and there is no probate, then if the PI lawyer serves the complaint on an office where the insurance company does business,
I see. Go
the
straight to
action
the
is commenced. If the insurance company wants to figurehead, they can come to the court and open one. But I currently have PI lawyers paying me thousands of bucks a year to open administratively wasted probate because of the way our statute of limitations
All right.
works. And
Yeah,
it's a
I
waste
get
of
it.
somebody's money, and it's a waste of the court's time.
I get it. Send it to Sandy.
Yep.
And
Got
Brooks,
it.
is
Done.
that gonna be introduced?
Thanks, Brooks.
I mean, is somebody gonna introduce that
I'll send it out.
legislation?
Oh, well, we could wrap it into this.
Because wouldn't that be under chapter 30?
Oh,
Because he's avoiding probate.
I think it could fall into 30 under the wrongful, when the wrongdoer dies statute. We could amend that one, and that was my intention.
can we do that?
What, do what?
Can we amend chapter 30 and this, to do what Brooks is talking about within the
Yeah.
scope of our relating clause and all of that?
It's 30.080.
Well, we don't
Because
have.
we don't have a relating clause. Yeah, you can, yeah, okay. Relating to estates of decedents and non-estates of defendants.
Don't have man.
That's a great one. That's almost as good as relating to taxation, yeah. Okay, well, let's send it in, Brooks. We'll take a look at it.
You got it. Happy to do it.
Okay, but I guess
Yeah.
you've already sent it in, you said, so, okay. Yep, because then I want to get to.
Yeah, Brooks, send it over and I'll get it out to the group.
So one other point is, in this process that we have now, how does a case get closed? The court is gonna want to know what triggers that general judgment, closing,
Oh.
supplemental judgment, or whatever.
That's a good question. And maybe something else that we need to add in section 7 as an affirmative.
So maybe they file the certificate, statement of compliance.
Right.
And then upon the filing of that, a supplemental, the general judgment closing.
Yeah.
Do you need to have a petition to close that file, or can you just?
The courts probably want a motion or a petition, don't you? For a general judgment, closing the estate and discharging the PR,
So if you had the settlement approved,
right?
aren't you just looking for receipts and the general judgment?
You even file receipts in it.
Yeah,
Okay.
that would be covered here. You usually do? Do you? Oh, really?
So they would file a statement of compliance of the receipts and then general judgment closing.
Okay. Okay. So let's shift gears and finish with a conversation about the shape of an intermediate process.
And I sent, in the last couple emails I've sent out, the notes which I had have been sent out to the group. Included,
Susan's memo.
Susan's
from
memo,
last
exactly.
October.
Yeah.
When we were about to get to this. Okay. I guess I want to open it up to just general conversation here for those of you who have been thinking about informal process and what.
Lane, sorry to interrupt. Brooks Cooper, I'm going to stop. Perfect, thanks. Bye.
So, who wants to lead off in starting our conversation about the intermediate process? I guess let's look at page 2 of Susan's memo. Tentative framework.
Can I back you up and
Yes.
ask the question of, because I've been discussing this with judges.
Okay, good.
And what is it that we want the intermediate to accomplish?
Okay, that's good. Good starting point then.
That's right, on the second page.
So- It's what I heard mainly was letters are needed. Or, $500.
For that,
At which point didn't we update the small estate statute to say you will treat this like letters in appropriate situations, or they can sue you for holding their money?
we did give the smallest, the affiant, the ability to bring an action against somebody who's withholding assets.
What are they?
But you can't get it in the small state.
Hmm?
You can't get the letters in the small state.
No. We did that sort of
You have the authority to go get your money.
Yeah, we said that a person holding assets is required to deliver them to the affiant, and if they don't, the affiant can bring an action and recover attorney fees.
So if
Yeah.
the New York legal department wants to be obnoxious, that's fine, the company can pay legal fees to fight about it.
So, yeah, so I have a legitimate question, and I want to get back to you on your conversations with the judges, because I know that's another enactability issue. I don't want to be in front of the committee doing battle with judges who will say, over our, dead bodies are bad pun in probate, but,
It's a survival action.
survival action, yeah. So, I mean, we've done that. We did that, I think, intentionally, at least to approach this issue of giving affiants real authority to collect these assets and viable threats of legal action against a non-compliant holder of those assets. Can we go the next step to an intermediate that actually gives something called letters? And I guess, yeah, Judge, what's
And
your...
that becomes, because that's the question that I have been asked.
Yes.
What is the purpose of
Right.
an intermediate? And does the language in the small state address the main concern that nobody's paying any attention to us?
Right.
We have, these certified copy of a small state act.
You said that with a demand letter that says if you don't really... So yeah, and collect attorney fees against you.
So have we accomplished what the
Good
intermediate
question.
is supposed to?
Good question.
Isn't one of the other reasons if you have highly leveraged real estate that's worth over 190,000, you can use the intermediate term probate? You don't have a lot of cash because the real estate is leveraged.
I don't remember that.
And the one thing I'm hearing from judges, the one thing that they're clear about is they don't want to increase the small state account.
Small estate and intermediate should be the same.
Well,
Then that begs the question, yeah.
Why are we doing it?
Well, but there still is, because there are times when you need to prove your will, or the exercise of a power of appointment, or that kind of thing, creation of a testimony of trust.
Yeah.
And then, yeah, those are kind of the main purposes, is you need to prove the will. But we've addressed the last one on the list, which is wrongful death. We've
Right.
addressed that, and it sounds like we're gonna address the legal and medical information even with the wrongful death, we're in that other PI statute. Oh no, that is actually sometimes,
Well, but if you're a wrongful death PR or a survival action PR, then you're a PR.
Right.
Right.
right, so then
Right.
we don't, so
So
we
we
don't,
created an intermediate process for those select instances.
and so those are eliminated, and so we still have, and the judges don't want this change in small state, so it still is, somebody needs to prove the will to exercise a power of appointment.
Hey, if we're talking ourselves out of the intermediate process, I've said before, I'm okay with that. But I want to make sure we deal with it seriously.
So do we specify, for example, because it looks to me like we're down to exercise power of appointment, does that become something specific in the special administrator part of the existing probate?
Is the special administrator just kind of temporary until the PR?
No.
No?
Uh-uh.
Oh. Well, the other thing that we could do is we could make a little statute that says that they don't follow the process in the wrongful death statute, if they have to prove the will and exercise power of appointment. And then they still have to follow that process, and if they don't find anything, then they can just close it. Or the special administration.
Yeah, John.
There are multiple purposes. One is, well, I don't agree that the limit should be the same as small state affidavit limits. The two different things, they don't have to be the same. But you want the affiant in the small state affidavit doesn't get letters, so that creates problems with the brokerages, and the insurance companies, and the banks. So having letters is important to facilitate the administration. Proving the will, because you need to, in order to identify non-probate beneficiaries or in order to powers of appointment.
Right.
That's another purpose. And in an estate that doesn't require a lot of supervision, the intermediate probate would give you a process which is essentially the same as a current full probate that ends with a verified statement. And the difference would be that you don't have to file the annual accountings, and you don't have to get the consent of all of the beneficiaries at the tail end in order to do the verified statement. That would be the difference between the two, which would be a simplification.
Okay, let's pursue that, because you could build that into the 114, 115, 116, the regular probate process.
Also, I guess, one point that you made, John, and I think is a good point, is I think it's worth thinking about the limits on small estate versus full probate, because in Salem, you can have a very modest house that is $300,000, and then the person has a $30,000 bank, and that's a full probate.
Well, so is the answer there just to propose an amendment to the limits?
I don't want to have the small estate limits go up, because those are the people who are out there, lying about their heirs and stuff. I don't know. I think it would be worthwhile to have, for a very simplified, solid estate, $500,000 real property, $100,000 personal property, and that would save court time, not having to do a full probate for these very simple estates. I've had a number of these recently where it's like, sorry, you have to have a probate.
So what steps are we proposing to cut out then?
Well,
But where are we gonna come up with a limit? Because if you're saying that small is $500,000 in real property,
intermediate.
and I mean, why not have it for a small estate as well? If that is considered a small real property, because my concern is.
Because she only trusts them so far.
Well, but I've just read a report that the highest housing prices in the entire country are in the Portland metro area.
Right.
Are we gonna base it on that? Are we gonna base it on Baker County, Hardin County? We can't, I don't think it's responsible for us to just kind of pull a number out of thin air saying this is a good amount.
Bonnie asked when the numbers were last adjusted. I'm going to guess it was within the last 10 years. Yeah, you can look at the date. John?
So the way I would envision the intermediate probate is that, I would have a procedure where any beneficiary of the estate who becomes unsatisfied with the way that the estate is being administered could simply file a notice with the court and the PR and convert it into a full probate. That I think would offer a lot more protection to the beneficiaries at very minimal administrative effort. They just say, I'm
On showing of what?
Well, I don't
Well,
think
just objection. You object, it becomes a
say, I'm
probate.
getting jacked around here, make this a full probate, and then, maybe it leads to a show cause or something, but it should be a pretty low hurdle for the beneficiary to get over, because you are eliminating all of the other normal protections that would be in full probate. And it's sort of, like we don't really do all this until somebody involved thinks that it is important to do it. Well, we don't have that option right now. In a small estate affidavit, if you have a problem with the applicant not doing their job very well, or cheating people, or being non-responsive, it's really, really difficult for a beneficiary to do something about it.
Summary review?
Yeah, but it's two-person process, and I like that idea. Plus, I think in an intermediate probate, you pay a full filing fee because it is something that could easily get turned into a regular probate.
Yeah.
So what you're avoiding then really is somebody has to ask for a final accounting, and you don't have an annual accounting. But the other thing is there would be time limited. I think Heather in her petition had proposed a time limit of 6 months. I believe a time limit of years.
I should be multiple years.
Well, but I think from the court's perspective, you know, they don't want it just languishing.
Chris? Oh, look, Kristen.
So then our baby PR is just running out into the world doing whatever they want and never reporting back to anybody, but they still have court letters. Is that what we're proposing?
I'm hearing the courts.
And at the very end, when the heir had expected, or the devotee had expected, you know, to get $7,000, and they say, oh, there's nothing here, then they get to file and say, we want this in a full-on probate, and that whole mess is dumped in the court's lap.
And the money's already gone.
And the money's already gone. And what I've experienced and what I've heard from the other judges over and over again are the worst ones. Right now in a probate, you've got to file certain things. I know it's moving forward. This is, I have no idea what's going on, and then there is this huge mess that's dumped here. Everybody's hotter than a firecracker about what was and wasn't done, and Judge, you're supposed to fix this. And the money's gone.
You could limit the PR to only be a professional fiduciary.
And you know, that really doesn't do anything either, because there's professional fiduciaries in the state of Oregon who've been criminally prosecuted, so, you know, but it's the issues that come up that no one has had to keep records, no one has done anything correctly, and you've got creditors and all these other people out there. It's all gone south, and then it comes into the office.
So when you have a full probate today, and an inventory is filed, and money is stolen, and the PR tells the heirs, okay, well, this is all there is, and they all sign a verified statement, and we close the estate with a verified statement. There's absolutely no oversight over what happened. There's no prevention.
But everyone looked at their verified statement and signed off.
They could have asked for
Where
it.
And you've given notice to creditors, you've had to publish, you've done all of these things to go out there
Which
to
you should
third
do,
parties.
which you should have to do anyway.
So what's the difference between that scenario and the intermediate we're talking about?
Well, except the date.
So why do we
You go to, you skip to a verified statement.
If we have a verified statement, why do we need an intermediate?
If you've done
Because
everything else,
if you go over 1 year, you don't file an annual accounting, and you don't have to get consent of all the.
Yeah, those are your two differences.
You just close it. And if you give the
Well,
beneficiaries.
you're not getting consent of all the people, and how is it consent by simply saying? It does not necessarily mean that there are people who aren't.
Well, either you get the
That's a good question.
either you get the direction from the testator in the will that allows for this process, or you get the consent of all the beneficiaries on the front, or it meets the statutory requirements. But it's a decision that it's just not worth our limited judicial resources to police this stuff unless and until somebody comes to court and says, hey, we have a problem.
Well, okay, you've raised an interesting point. Maybe another way to look at this, maybe not. But we do allow, for instance, the statute requires the filing of a bond, but we expressly allow a PR to waive that requirement when they're appointing, in your typical family situation. All of us draft waivers of bonds, and we do it comfortably because we're not worried about the person that our client is appointing as the PR taking the money and running off to Rio and disappearing with it. Should we allow, as an alternative to this approach, should we allow wills to expressly waive other provisions of the probate code? Limited ones, certainly not notice to creditors, but, waive a final accounting, but that may be important to creditors. Yeah.
Well, but that would be only insolvent estates. And that was the whole premise of this is.
Well, that's true.
Applies to solvent estates.
Yeah.
Right, I don't
It's
think-
solvent estate, you have a record.
Yeah, I don't think you do this in insolvency.
But even in a solvent estate, creditors need to get notice. I mean.
Yeah.
But that, this is like the small state process in that creditors do get notice, they're required to receive.
Well, no, I'm suggesting that we kind of create a virtual intermediate process like John is talking about. We don't create a different process getting up to, let's say, that last point. But we authorize we say that a PR, just like they can waive the requirement of bond, they waive the requirement of a final, annual and final accountings if my estate is solvent.
You're talking about the decedent, right?
Yeah.
PR.
Oh, yeah, I'm sorry, yeah, the decedent in the will. Yeah, saying, you know what, I trust you entirely. I don't know,
Where you can get it, where you can do it by consent, basically you get a verified statement at the beginning, where you can do it by limit, if it's under a certain limit, that this is the process unless somebody objects to it. But I think the police function comes from a simple procedure for the beneficiaries to follow to kick it into a full probate.
Well, you know, Chris raises the point, if you're not filing a verified statement, you know, that everybody has signed off on, does that necessarily suggest that somebody doesn't agree with it?
It's not, it's, people are difficult. But you got people that,
Yeah.
that
Well,
refuse
the
to accept
non-response,
it.
not the active objection.
Right.
Can I ask,
Yeah, but
do other states have this intermediary process?
Washington has it. We invited, we had a judge and a lawyer down from Washington, and they got eaten alive.
Their intermediate process is the whole thing.
I get it.
Yeah, Washington does have this process. What did we find out? There were several other states that have something like it.
Process. A lot of states do. Texas has.
Yeah,
has one,
right.
We're not plowing the ground.
We're plowing new ground in our field. Yeah, but other fields are growing them.
But I think that one of the distinctions is Oregon has the verified statement. We have a very, I mean, it may seem cumbersome in the state of Oregon, but you look out to other states and they have a very cumbersome probate process. Oregon is just kind of, we file these things, here's the verified statement. Here, we're all good to go.
So I guess a big part of the concern is the annual accounting. So one thing that you could do would be to say the annual accounting is waived and is substituted for the informal report, like you do in minor conservatorships where they have to show a copy of the bank statement or whatever, as long as all the creditors are paid and all the beneficiaries are consented, or all the creditors and unpaid creditors and beneficiaries consent. If you do that, which would be very similar to a verified statement, and the court would then have the proof that the asset exists. Those annual accountings, they're so expensive and painful.
What's the definition of the proposed
Well,
intermediary state? What's the definition of proposed? So right now it's at, small states 200 and.
Yeah, we have a set on the value.
And to answer your question, it was changed in 20.
Okay, thank you.
If our annual accounting is so undocumentable, shouldn't we do that before we get to the final accounting? Doubly undocumented?
What's that, Chris?
Well, Jennifer was talking about the concern being, you know, how hard it is to pull together an annual accounting. I'm sure we've got some other clients on that it's pulling teeth to get all the information you need. But at the same time, if I had to go back and do a final accounting without having done the annual accounting, I would be pulling more teeth and they would have no idea what had happened.
Well, but I assume that when I see verified statements in lieu of final accounting, that you haven't just, and maybe this is my naivete, you haven't just shoved the document under an heir's nose and said, sign here.
Oh, you're naive.
Yeah. It depends.
Don't burst my bubble.
When we send notice saying this is what's here, and unless you want to go through the expense to the estate of forcing this,
So is
don't
there,
make us pay that extra expense.
I've got something here that I know what your, ballpark may be.
I do the check register.
Yeah, right.
But you don't have to do all of the descriptions and.
You just, well, you do what you need to do to get their consent, and some people
Some more
just don't care. Yeah.
So do we give the heirs, the deceased, the option of waiving an annual accounting? As in a verified statement?
Yeah.
I think you have run, and then that's what you hold proceeding. And they can
Yeah,
always
but they
change
need
it.
to have the ability to undo.
Well, they do, yeah.
Well, the other thing you can do if you're not comfortable with that is put your estate's under X number of dollars.
Well, I don't know, I mean, if it's,
But, you know, if you have $1 million estate, everyone gets along, folks. It's-
right. That's, well, okay, let's, again, kind of a virtual intermediate process. Brian,
No, they said when it's.
okay, all right, yeah, the dollar amount isn't necessarily the issue. Yeah,
So why not have that in the full-on probate?
well, that's what I'm saying. You mean, we just, again, trying to create a kind of a virtual process here that further simplifies our full probate without creating a third process. So,
Why have two processes that don't have one difference?
well, that's right, or two. Well, yeah, I guess the one would be, I mean, is that it? So we have a waiver by the beneficiaries of the annual and final accounting. That waiver can be revoked at any time during the process.
And that's only for a solvent estate. Right.
Well, but see, the other thing that you could do, because again, sometimes you're just waiting for something to sell, is if there is a creditor that's unpaid, the creditor could consent.
Well, we haven't been talking about giving creditors consent.
Well, we haven't before, but we can create.
I mean,
Well,
I wanna-
you're a big creditor and you're consenting to the waiver of the accounting because you don't want her attorney fees to be an additional
And then-
$5,000.
if we had to give consent, that's fine. I don't have a problem with that, but I think a lot of people will. And,
Right, we have the choice.
yeah. Well, if you get creditors' consent, I can't object.
That one, to me, that's more trouble than it's worth.
Well, that's what I figured somebody was gonna say.
Yeah.
I mean,
You got to insolvent estates.
What's the chances that PGE is gonna give you consent? They send you a $50 bill, and so you send them this document to sign, and they're just gonna,
Yeah.
and there's your
And then
consent.
you have to.
Yeah, they might as well.
Okay.
But if you have one named creditor and you know that you're negotiating the sale of a piece of property and it's gonna sell in 3 months, and you say to the creditor, look, if you waive this, here's my check register. If you waive this, it'll save us X amount of dollars. They very well could.
So just be mercenary about it. If you got an insolvent estate. Hey, Lane.
Are we done?
No. If you have an insolvent estate, the PR is getting paid for serving. The lawyer's getting paid for doing the legal work. And the creditors are getting whatever's left over after all. So the final account is no longer a problem. When you do it,
Right.
the creditors are paying for it, you get paid.
Right.
What's wrong with that?
Well, that's not really the scenario that we're looking at. We're looking at that, the beneficiaries all get along, and it's a fairly simple remaining time of what has to happen, and probably all the creditors are paid. But maybe the house hasn't sold yet because there's having repairs or whatever, and there's one big creditor or whatever that they, a lot of times the beneficiaries don't get creditors off in that situation, just, I don't know, to me, this, it does, it's simpler, it avoids the whole separate process.
Right.
And if we could, we could call on that in the probate, and have that, how we get our real,
Well, I'm sort of, I'm almost more inclined to amend the special administrator statute to allow that to be done that way. If that's all you want. 113, because right now it does say prior to filing of an estate. So this would need to be something that is not just prior to, this may be all you're doing.
Maybe just have a provision that
That's what I'm
allows-
saying, yeah, in the special administrative statute that says that can be accomplished, and not in the context of something that is proceeding to the filing of a full estate. You can, you can file, we can use a special administrator statute to prove a will, create a testamentary trust, exercise the power of appointment.
Then you're gonna have to eliminate the requirement of filing a bond, and then.
But let's,
Well, but if you're doing it to prove a will, your will either waives or doesn't waive the bond. And you should be stuck with that.
I mean, isn't it simpler to just open a probate? As it exists today. And then when it comes time for filing the inventory, you file a statement that says there are no assets to administer, dismiss the proceeding.
well, okay, and that's,
Because it really, that wrongful death probate, it eliminates all those things, and all you do is you file a statement of compliance. And
no, but I like what John's going, you file it, you do all the stuff, and then we create sort of an escape ramp at the 90 days, that in lieu of an inventory, if you file a motion, motion to dismiss for, for one of assets.
So you still have to file notice
Yes,
and the publication.
and publication,
And publication.
yeah,
And
yeah,
affidavit in compliance.
pardon, sure,
Affidavit in compliance.
sure.
I think it's a great idea, because there are other reasons why. Well,
I
because
got her up
sometimes,
this probate perfectionist.
Well, all of those things, the affidavit of compliance, that could all be incorporated in what's required in the motion to dismiss the probate. So we're not, yeah, because I want to go back and amend that because that occurs later. That affidavit of compliance occurs later. So I would just incorporate those same requirements in the motion to dismiss for lack of assets.
well, dismiss for lack of assets or other purpose, because sometimes,
Well, what do you mean?
sometimes your purpose is you want to waive the attorney-client privilege, you want to waive the.
Well, okay, but then you're saying there's no assets, so we don't need to do anything else.
That's
Yeah,
true,
yeah, you've done what you needed to do. And you just don't have any assets to carry on the rest of the estate, so we're gonna close it.
So then, do we need to state that there don't have to be assets to open the probate? Because Heather had this one, when she had, it was Ann Ritter, he had to say that this guy in prison had died with a radio. That was how he opened the probate, so the PR could waive attorney-client privilege. And then we're saying, well, you don't have any assets.
Well, let's look at, if you don't have, do we not have?
That's why you don't have to.
Here, I think I know it.
Okay, that would be a simple amendment to the petition requirements.
Yeah, so you just, you go through the process. The other thing that I think the other thing that you need is exemption. So if you're gonna go through this process.
You're just chipping away at this, John.
Yeah. There's no need, if you don't need to get the final distribution approved, why would you need to get the intermediate distribution approved? As long as
Well, because
you've got a solid estate and you want to make those distributions.
Well,
the final distribution is you've taken care of all the issues claims concerned.
yeah,
For an intermediate distribution, you're dropping assets out of the estate theoretically before we've dealt with
yeah.
all the potential
The
issues.
day
claims,
after
and
is the
concerns.
others that are issued.
Yeah, I wouldn't be so warm to to that. Because it may be solvent, but it may be insolvent after you do the distribution.
I think if you just have it be for zero asset estates, So at the time of petition, there's 0 assets, at the time of inventory, there's 0.
Yeah, but John's talking about something else. He's going back to the exemptions for, oh, yeah, so, so, and we got that, we're gonna create a motion to dismiss, at the point of the inventory.
Okay.
That's right, so you gotta do all the notice up to that point, and then in the motion to dismiss, you have to say that you've done a diligent search for creditors and you don't have any assets, and we can dismiss the estate.
And so whereas.
Lane,
Yeah, is that Matt?
this is Matt Shaw.
Yep.
Yep. Why is if we want to close a probate because there's no assets and we opened it for some other reason, why are we doing a motion to dismiss it rather than just a final accounting that states that there's no assets and it's ready to be closed?
Yeah, same thing.
Yeah,
So that's what you put on the top of the paper, that's all.
okay, yeah.
Somebody.
I didn't hear that.
Yeah, John is just saying, we're talking the same thing, it's just what you call it.
Well, and so the other thing is in verified statement, you have to say all taxes have been paid, and if there are no assets, which taxes, you don't.
Right.
You can't make that statement.
Right,
So, but you can
But you
just
can file an
petition for
accounting
summary
that
closure.
says, "Fuck this,
yeah,
I have 0.
nothing has changed, there is nothing to distribute or pay creditors, let me act."
yeah,
But the verified statement and final accounting section says you have to make a statement on taxes.
right, so we won't incorporate that requirement in this motion or this final,
I think what Matt's bringing up is, why do we need to change the statute? We could currently file a final accounting that says insolvent estate, started with nothing, no changes, ended with nothing, nobody's getting paid. Please close this estate.
But even now, there's petitions for summary closure, saying exactly that.
yeah,
We open the estate, turns out the property belongs to Mary.
Yeah.
It's not Fred's. Close it.
yeah.
Okay, we're good.
So that's what it's called, petition for summary closure. What's that?
It sounds like we don't need to make new law.
Well, or if I were to look for the statute that authorized, well, yeah, what is it? There isn't. So,
We do need to make a law, because if you have no assets, then there's no need to publish notice. There's no need to search for creditors, there's no need to do anything. So if all you've got is a will that you want to prove in order to validate the power of appointment, and you have no assets in the probate estate, then you prove the will and close the estate. No affidavit of compliance, no publication of notice, no nothing.
So I've not what I
yeah, that's shortening it up even more. Rick?
But that's what we need.
Well, but I think you need notice to,
Not if you don't have any assets.
Yeah, I mean, that goes back to why we waived all those things in the law for that, is there's no assets.
Rick?
Well, okay, so.
If you want to prove a will, then you need to have an opportunity for somebody else to come forward and say that's not the will.
That's true, you do.
You notice the beneficiary, the heirs and depotees get notice, but you don't get creditor notice, I'm sorry.
Yeah, so there'd be information over years, notices, there'd be DHS, because they're part of it, you publish. Why would you? Because there's no assets.
There's no assets. There's nothing to administer. You wouldn't, under our current law right now, you wouldn't have probate because there's no assets to administer, there's no estate. So
Yeah, I
you
get
can approve the will, so if we allow you to come in and prove the will, and then say, okay, well, now you got to do it.
So what we need is a statute that says when a petition for summary closure, I like that, can be filed. And it's before publication of notice.
Notice the heirs and depotees for sure, because they can contest the will.
Okay, but do they still have 4 months to contest the will?
Well, if you have to.
Yeah, okay, right, that's what I'm saying. So then what we do is we suspend the timelines for all these other things Because the statute has, we've got deadlines after, 90 days after when we file the inventory.
But in this case, we're still requiring an inventory, we're just saying it would be an inventory that says there is, we looked and there is in fact not. But
Well,
it's-
some states have a procedure where you can initiate a probate that, approves the will. And just check a box with your petition that says no administration is necessary. So, you go into court with a filing system, we have no assets, we have we're offering the will, proving that people have their 4 months to contest it if they want to, but there are no assets, and we never even, in those states, you never even get to these questions.
Yeah.
But we can do that the other way around, easy enough, it's just one more file, and just a summary closure of some sort.
And I'm, excuse me, I'm presuming, of course, since there's no notice to creditors, this in no way would, they wouldn't be precluded if
No.
there was some
Yeah.
new opening.
Constitutionally, they wouldn't be, yeah.
So the
Well, you get your preclusion.
I beg your pardon?
So we get preclusion through notice, and it's in the notice rule, so if we're not getting you notice, we don't get our protection because we're avoiding that rule in its entirety.
Just
So this is creating a no asset process where you make that statement in your petition.
If you know it.
If you know it, yeah, if that's the purpose of it, that there's no assets. And if there's no assets, then all you have to do is the no information to heirs, devotees, interested persons, and nothing more until 4 months.
From the mailing of.
Yes,
notice.
and then you file your petition for summary closure.
Yeah.
Judge, what do you think? Okay. That's elegant.
So the publication of notice is 113, 155, and that just says upon appointment.
Right, well, we would have to, we'd have to be clear that these things don't apply in a no asset
Right.
estate.
Well, we could, I don't,
What?
yeah, that's fine, you don't need an appointment. If you know up front you have no assets, and all you're doing is validating the will, then you don't.
But you've got to say that this, because it says a failure to cause the notice to be published is a breach of duty.
Yeah, right, yeah, we'd fix that.
Well, I think we're.
Yeah. You-
We're trying to not get a PR appointed.
No, we've got to have a letter.
Yeah, the special administrator, right?
You what?
And proof of the
The
will.
whole point is you want letters.
Well, I thought we were looking at situations where we just needed.
This is a different purpose.
PR.
In a no asset case, I think you don't need letters, but I don't know that I want to, but you still have to identify yourself as a personal representative in the petition.
One of the reasons for the letters was to get medical records too, so if that's part of why you're got a wrongful death case and you need medical records.
But that's.
We've got, but the wrongful death, you're going to be filing your wrongful death
So if
petition.
you want to call this person, if they don't need letters, we want to call them the special administrator.
Well, this gets us back then to the special administrator statute.
Because if we're narrowing it down, giving you your specific authority and allowing you to file a summary closure, and this is out 4 months, so that if you find assets, you've still got an inventory
Right.
department.
Right.
And it's like, oh my gosh, look what we've got here, we're gonna file an inventory, we need to come back and amend our petition.
Uh-huh.
So if you go beyond the 4 months, or beyond, you've got your 4 months, there's no will contest, and you just listen.
Yeah.
Can I ask a question?
Yeah.
Just to make sure we're all on the same page. So we're now.
Oh, we're not.
We're all moving away from the discussion about an inching various date, and now we're gonna talk about the statute for a no.
That's right. Yeah, because this was one of the reasons we had talked about an intermediate, one of the functions of an intermediate estate. But now we're talking about it very specific to a no asset estate. Yeah.
Which dovetails in, do we even need the intermediate process?
All right, I think if we did these two things, we would. If we did this waiver of the annual accounting option. and
Right.
no asset
Yeah, yeah. Right. Yeah, I'd say we've
That is
created,
the intermediate process.
we've created a virtual intermediate process. I like that.
And do we need to run that?
Huh?
We still need to run that, or that's.
And
no
run that.
assets.
Yeah, okay, but no, but yeah, Marissa asked the question, is it wrong with them now just have no asset estate? Okay.
I think we want all those protections that we have.
'Cause it may not be technically an asset, but you're dealing with something of real value. Okay, that's why.
Well, if I could switch discussions a little.
What about intermediate death?
Intermediate death.
It's a good concept.
You know, I'd like to be able to file a probate that appoints the PR, proves the will, and be able to say, I don't know that there are no assets. There may be some, there may not be any. So I want the authority as PR in order to go find out if there are any assets. And if there are, then we'll deal with it.
Right.
At the time of the filing of the petition, of the inventory, which is kind of what you have right now.
Right.
You get appointed and then you marshal the assets and file an inventory. In the opening petition, you submit some rough estimate of what
Right,
is in
right.
the state. But the only purpose that serves, that I can discern, is to establish the filing fee.
Yeah,
So.
right.
So wouldn't that be solved by simply saying, you know, at some, I don't know, prior to filing an inventory draft or something like that, if there are no current assets,
right.
a summary closure can be filed.
But in that case where you are filing for the purpose of searching for assets,
Yeah.
where there may be, I think then you still have to do the publication.
When you find it.
Huh?
When you find the
No, then we're really complicating things.
But I think it's really kind of simple, because like that situation where it turns out Aunt Sally owned that property, we didn't know that. I think it's kind of simple, they get their letters, and then at 90 days, we found nothing, we have notified the information, the heirs and depositees in DHS, we've done that, we don't need to publish. And then we close it, and I don't really see the harm of the person having, because it's still probate, the court can still demand all these things happen if they haven't checked out.
So, okay, but then what do we do in the publication statute? Right now, it's just automatic.
But you know, there is no deadline on the publication statute. It doesn't say it has to be done within, you know.
It just starts your 4 months running.
Yeah, that's true. That's true. That's different than the 30 days.
And say, let's find out, you know, if there's assets here and we'll put it off. You're just kind of pushing out.
Yeah, you're right. Okay, you're right.
So you could just add a subsection in that statute that says, this provisions of the statute are waived if the court approves a petition for summary closure.
Well, they're waived because the estate's closed, and so there's, yeah, I don't think you need to, you really need to say that.
Like
Linda?
regardless of what we call this, are there gonna be letters issued?
Yes.
Yes,
And then my question is after that, if you've issued letters and basically, I'm unclear on this, giving them the authority to start marshaling assets they discover, but they've given notice to, how do we keep them from?
Well, then they have to file an inventory, and then it's proceeds as a regular probate.
Then you don't get to file a summary closure because you've got assets. This is only if you have looked around and said, I got nothing.
you know, this really saves,
I guess what I'm getting at is what prevents them from marshaling the assets and then going back to the court and saying, well, I found nothing.
well,
It's not totally good.
That's fine.
yeah. That should be a crime. Wait, it is.
I should mention that this is actually being done in the 2 counties that I've worked in.
Uh-huh,
We allow people to open a state saying that it's unknown,
yeah,
and then they'll go out and they'll search, and then they'll just file it, you know, somebody's gonna be,
All right.
we're allowed.
It's a practical procedure, it's just not statutory.
right.
And that's what I'm just saying. Let's
Nothing better than conforming law to practice.
Right. Point to it and say, let's-
And Darren mentioned how, you know, does publication really accomplish?
It satisfies a constitutional requirement.
If you wanna.
All right, so, okay,
And we shouldn't be routinely generous with publication of notice to creditors, because it's a very expensive.
Yeah. No, I agree. So this is cost savings to parties. It is cost savings to the state because we're getting these cases out of the system early and not requiring the court to handle filings that are meaningless.
And you can have consistency statewide.
And you can have consistency statewide.
And
Yes.
make requirements for the motion saying, you have to declare or certify.
Right.
There is nothing.
And that's the consistency.
So let me give you a case I just had as an example. Osmosis, a probate was open because this woman's husband died. None of this was dealt with in his living trust. 20 years previously, his 1957 Cunningham C3 had been stolen from a.
It's a car.
It's a car. And it turned.
Leave it to John.
It turned up in the hands of a wealthy collector who was planning on selling it at an auction for. They ultimately sold for like $300,000. The probate was open to give this woman letters so that she could bring a claim against the collector to establish the ownership of the car.
Yeah.
And it was all, factual. So what happened 20, 30 years previous. In that case, we ended up negotiating a settlement, but it could have just as easily turned out that she failed.
Yeah, right.
And she got nothing.
Right.
So in that situation, why do you need to give notice to creditors?
Yeah.
Why do you need to file accounting?
Yeah, right. No.
But it took about a year.
Right.
Between her previous lawyer and me, it took about a year to actually get the thing resolved. And it can take time.
So what I would like, you say you're going to send out our next meeting is September 27th.
September 27th, yep.
That gives us a few weeks in between for a smaller group who wants to volunteer to do some drafting around these concepts that we've talked today, so that we'll have some language in advance to look at for our next meeting and hopefully then accelerate our process. Who wants to volunteer? John. Okay, there's 4. Good with that? Shannon, to the extent that we are also going to be looking at wrongful death, will you volunteer too?
Yes.
Okay. Well, okay. Brian, John, Jennifer, Shannon, and me. Well, Rita just appointed. Okay.
Oh,
Who
there
are
you go.
going this time?
Enjoy.
My daughter's wedding is in
Well, that's exciting.
It was Africa last year, right? Jeez. Okay. So, Brian, Sandy, did you get those names?
I have Jennifer, Brian, John, Shannon, and Lane.
Okay. And
and
so that's right. So we will send out an email to schedule a meeting of that group in the next 10 days.
Does that group want to meet in person or I could do a video conference? It's up to the group.
Well, if it's not gonna be in Salem, I'd like to do conference.
We could do it in Salem.
Yeah, John, could you come down for one of those meetings? Could you come down to Salem so we could have an in-person meeting with this group? Good. All right. So.
Or I could set up a good video link as well if you're.
Yeah. I think it's worth being
Okay.
present.
I'll try.
So Heather and I are still working on top of all that.
Okay, good. Glad to hear it.
And we're meeting on Thursday, and is there a way we can do regular meetings so we can schedule that in our calendars? She had a conflict.
Every time I've ever sent out scheduling links in the past, that hasn't worked, but because people have irregular conflicts, but I'm very open to trying.
Well, I tell you what, we're the next meeting is the end of September. We're talking about scheduling
October,
November, December. Let's do 3 months.
Okay. Yeah.
No,
well, not right now. I found that that's not possible, but I'll send out a link either later today or tomorrow to try to attempt to do that for all 3 months.
And for those of you who are really work junkies, when is capital workplace harassment work group meeting?
Unfortunately, they're literally going to be at the same time.
Oh.
There was no other way to do it. But they're in the same building, so if you want to stop by. So the 27th, both meetings are in the. I know there's
Amy's
nothing.
laughing.
There's nothing else I could do.
Yeah,
Um,
sex and death, all together in the capital. Be
27th
there or be square.
in the Capitol. I'll send you all information about the room. This group is going to be. I have the room set. I'll send over all the information which room in the Capitol.
All right, thanks, everybody. Great meeting today. It must be because Bonnie was with us, I guess. No, good meeting. We'll talk to you all again. Adjourned.
Oh, I'm sorry. I actually missed it. If anyone